Imagine spending years creating something only to discover that the law says it isn't even an invention. That's exactly what Section 3 of the Indian Patents Act does. It lists things that cannot be patented, no matter how creative they may seem. In this video, we'll master Sections 3K to 3P using simple explanations and easy examples. Let's begin. Section 3K states that a mathematical or business method or a computer program per se or algorithms are not inventions under the Patents Act. Let's understand each one. A mathematical method is simply a way of solving mathematical problems. A business method is a method of carrying out commercial or financial activities. A computer program per se means software by itself, without any technical contribution. An algorithm is merely a sequence of logical steps to solve a problem. For example, suppose you develop a new algorithm that sorts numbers twice as fast as existing algorithms. The algorithm by itself is not patentable under Section 3 as K. So Section 3K tells us that ideas expressed as calculations or software alone are excluded. But what about creative works like paintings, songs, or movies? Let's see. Section 3L states that a literary, dramatic, musical, or artistic work, or any other aesthetic creation whatsoever, including cinematographic works and television productions, are certainly valuable. But they are protected under copyright law, not patent law. For example, suppose an artist paints a beautiful landscape. It may be original, but it is an artistic work, not a patentable invention. Now let's move from creative arts to something completely different. A Section 3M states that a mere scheme or rule, or method of performing mental act, or method of playing game are not an inventions. In simple words, rules, plans, and ways of thinking are not inventions. Imagine you invent a brand new strategy for winning chess, but it is simply a method of playing a game, so it is not patentable. Similarly, a method of solving Sudoku in 5 steps is only a mental method. We've seen ideas, we've seen creative works. Now let's talk about information itself. Clause N states that a presentation of information, even in a new way, is not an invention. Suppose you design a weather report that uses colorful symbols instead of text, so that people can understand it more easily. But you've only changed how information is presented, not created a technical invention. So it is not patentable. Next comes one of the shortest clauses in the Act, but it is often asked in the patent agent examination. Clause O talks about the topography of integrated circuits. Topography means the three-dimensional layout or arrangement of an integrated circuit. Such layouts are excluded from patentability under the Patents Act. Suppose an engineer creates a new layout for placing components on a microchip. That layout itself falls under Section 3.0 and is not patentable under the Patents Act. Finally, let's look at one of the most important provisions for India. An invention which, in effect, is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components. The purpose is simple. Nobody should receive a patent for knowledge that has been known in traditional communities for generations. Similarly, merely combining traditionally known ingredients without creating a genuine invention is also excluded. This medicinal use has been traditionally known for centuries. Therefore, it falls under Section 3P and cannot be patented. Before you go, here's something to help you revise even faster. If you found this video useful, hit the like button. Subscribe to The Patent Scientist and turn on the notification bell so you never miss the video. And here's a bonus for you. Comment Section 3 below, and I'll send you a free PDF containing summary of all Section 3 easy memory tricks and practice MCQs to test your understanding. Go ahead and comment Section 3 now and start revising smarter. Thanks for watching, and I'll see you in the next video.